So, the topic for today is the purpose and type of records, especially in relation to occupational health. I am Dr. Sangeeta Narang speaking to you. The contents of today's presentation would include the introduction to the topic, the historical development, occupational health and safety rules and acts, especially in relation to Indian perspective. We will be discussing the Indian Factories Act 1948 little in detail, and then the occupational health records. The Occupational Safety and Health Administration, also known as OSHA, classifies occupational medical record as an occupation related chronological cumulative record regardless of the form or process by which it is maintained. The maintenance may be in the form of a hard copy, electronic form, microfiche, microfilm, or automatic data processing media. Let us understand these three words that it is occupation related. So the information that we are storing in a medical record, first it is a medical information and it is related to the occupation of the person. Second, the word chronological. That means in the order of appearance, that is, if it is in January, then July, or if it is year wise, then maybe 2000, 2001, 2002, and cumulative record. So, in a chronological order, and we maintain all the record. So, these three terms are important. Let us look at the historical development of occupational records. As early as 1916, Simon Forman's and Richard Napier's casebooks are the most extensive set of records. In the early 19s, there was not much progress. It was only in 1961 that the Committee on Industrial Medical Records and Council on Occupational Health declared that industrial medical records should provide data for use in job placement, in establishing health standards, in health maintenance, in treatment and rehabilitation, in workmen's compensation cases, in epidemiological studies, and in helping management with program evaluation and improvement. If we look at this definition carefully, or the recommendation is quite comprehensive because it starts from job placement and goes towards compensation cases and covers all the aspects. Now, what are the occupational health and safety rules and acts in our country? These have been listed very well in your module. It will not be possible to get into the details of all these acts and rules, so we will just be naming them. The Atomic Energy Factories Rules 1996 and also the Atomic Energy Radiation Protection Rule. We all know that radiation has important health hazards, so these two rules relate to the radiation protection. Then we come to the BD and cigar workers. In this again there are, one is the BD and Cigar Workers Act 1966, that is the conditions of employment, and later on its Employment Amendment Act in 1993. We also have Bombay Shops and Establishment Act 1948, then building and other construction workers. We all understand that this is the unorganized sector of construction workers, but they are also regulated by the Building and Other Construction Workers Act 1996. This has come quite later than the previous acts. Then coal mines. Coal mines regulation we all know is a hazardous occupation. Then Code of Criminal Procedure of 1973. Then sometimes the industrial workers are dealing with the dangerous machines. So there are acts related to the dangerous machines, that is the Dangerous Machines Regulation Act 1983 and the rules in 2007. Even the shops and establishments are covered under occupational hazards and Delhi Shops and Establishment Act 1954. For dock workers, we have Safety, Health and Welfare Act 1986 and regulations in 1990. Then there is a draft policy of the government on OSH issues in our country. We next come to a very important scheme and the act related to it, that is the Employees State Insurance Act, also known as the ESI Act. The amendment came in 2010. The initial act was formulated in 1948. We will be discussing little in detail the Indian Factories Act 1948. We also have the Indian Boilers Act, Industrial Disputes Act and insecticide rules. Then there are Interstate Migrant Workmen Act 1979 and Shops and Establishment Act specific to Karnataka, Labor Inspection Country Profile of India. Then Maharashtra has two acts, Shops and Establishment Act and Manual Workers Act. Then there is Mahatma Gandhi National Rural Employment Guarantee Act, Maternity Benefit Act 1961, then Mines Regulation 1960, Mines Crèche Rules and Mines Rescue Rules. Motor Transport Workers Act 1961, National Policy on HIV/AIDS and the World of Work, National Policy on Safety, Health and Environment at the Workplace, Oil Mines Regulations, then OSH related laws in place and policies, Penal Code, Persons with Disabilities, that is the Equal Opportunities, Protection of Rights and Full Participation Act 1995, Plantation Labor Act, Public Liability Insurance Act and Public Liability Insurance Act Amendment in 1991. We have the Punjab Shops and Commercial Establishments Act, then rules for manufacture, use, import, export and storage of hazardous microorganisms and genetically engineered organisms or cells. See, these acts are not applicable at all places. So whatever the industry or occupation is, one has to go into detail of the relevant act. But there are few acts like the sexual harassment of women at workplace. This is applicable at all places. Then the Tamil Nadu Manual Workers, Explosive Rules, Indian Boilers, Indian Electricity Act, Indian Electricity Rules, Insecticide Act, then Manufacture, Storage and Import of Hazardous Chemical Rules, Mines Act, Solid Waste Management Rules, Noise Pollution Regulation and Control Rules, then rules for manufacture, use, import, export and storage of hazardous microorganisms, Workmen's Compensation Act, Trade Union Act, Unorganized Workers Security Act, and Workmen's Compensation Act. Let us now see one act in little in detail, that too the parts which are related to occupational health. Now, section 41B. We will be dealing with few sections of this act only. Section 41B in the Factories Act 1948. It says that a compulsory disclosure of information by the occupier. That means the person who is occupying or running the factory or the establishment. So, under this, they have to disclose the following information compulsorily. 1. The occupier of every factory or workshop involving a hazardous manufacturing process shall have to invariably disclose prescribed all information regarding the dangers, especially including the health hazards and the measures to overcome such hazards arising from the exposure to materials or substances in the manufacture. Please note these points: in the manufacture, transportation, storage, and other processes or handling. At any step, if there is a health hazard, they have to intimate. If the same to the workers employed in the factory, the chief inspector, the local authority within whose jurisdiction the factory is situated, and the general public residing in the vicinity. In case the hazardous material can affect the nearby areas, the public residing in the vicinity also has to be informed. Second, the occupier shall, at the time of registering the factory involving a hazardous process, lay down a detailed policy with respect to the health and safety of the workers employed therein and intimate this policy to the chief inspector and local authority, and at prescribed intervals inform the chief inspector and local authority in case there is any change which has been made in the policy. The information furnished under subsection 1 will include accurate information as to the quantity, specifications and other characteristics of waste and the manner of their disposal. The waste coming out of the industry is very important, has many health hazards, and this has to be taken care of. Fourth, every occupier shall, with the approval of the chief inspector, draw up an on-site emergency plan and detailed disaster control measures. These disaster control measures should be in writing for the factory and made known to the workers employed and the general public living in the vicinity of the factory. And the safety measures required to be taken in the event of an accident taking place. In fact, 6 monthly disaster drills are also recommended. Every occupier of a factory shall also, if such factory is engaged in a hazardous process on the commencement of the Factories Act 1987, within a period of 30 days of such commencement, and also if such factory proposes to engage in a hazardous process at any time after such commencement, then within a period of 30 days, let us understand that a stipulated period of 30 days has been given, that before you start this process we have to inform the chief inspector of the nature and details of the process in such form and in such manner as may be prescribed. Sixth, if the occupier of the factory contravenes the provisions of subsection 5, the license issued under section C to such factory, notwithstanding any penalty to which the occupier of the factory shall be subjected to under the provisions of this act, be liable for cancellation. In simple words, if the provisions of the act are not adhered to, the license can be cancelled. Seventh, the occupier of a factory involving a hazardous process shall, with the previous approval of the chief inspector, lay down measures for the handling, usage, transportation, and storage of hazardous substances inside the factory premises and the disposal of such substances outside the factory premises and publicize them in the manner prescribed among the workers and the general public. Now we come to section 41C. Section 41C of the Factories Act says that there is a specific responsibility of the occupier in relation to hazardous processes. In case there is any hazardous process, they will maintain accurate and up-to-date health records, or as the case may be, medical records of the workers in the factory who are exposed to any chemical, toxic, or any other harmful substances which are manufactured, please note the words either manufactured, stored, handled, or transported, and such records shall be accessible to the workers subject to the prescribed conditions. They will also appoint persons who possess qualifications and experience in handling hazardous substances and are competent to supervise such handling within the factory and provide at the working place all the necessary facilities for protecting the workers in the manner prescribed, provided that where any question arises to the qualifications and experience of a person so appointed, the decision of the chief inspector shall be final. The provider will also provide for medical examination of every worker. That first is the pre-placement, that is before such worker is assigned to a job involving the handling of or working with a hazardous substance, and also continuing, while continuing in such job and after he has ceased to work in such job. So pre-placement, during placement, and after the placement at intervals not exceeding 12 months. The interval can be shortened depending on the hazard involved. There are various forms under the Factories Act which need to be maintained. These are also given well in your module, so you can have a look at the forms. They are application for permission to construct, extend, or use any building as a factory, application for registration and grant of renewal of license for the year, and notice of occupation specified in section 6 and 7. Form 3 is the license to work a factory. 4. Notice of change of manager. Form 5, certificate of fitness. Form 6, record of the eye examination. 7, record of lime washing, painting, etc. 8, humidity register. Form 9, register of workers employed for work on or near machinery in motion. 10. Report of examination of hoists and lifts. 11. Report of examination or test of pressure vessels or plant. 12. Register of examination of gas holders. Then examination of water sealed gas holders. All these are important because in case there is a bursting of any of these cylinders, it can lead to a lot of disaster. Then register of compulsory holidays, overtime muster roll, periods of work, and register of adult workers. We all know that below a particular age, that is the children, cannot be employed in factories. Notice of periods of work for child workers, register of child workers, register of leave with wages, and the leave book. Then nomination for payment of pay due for period of holidays in case of death of worker, certificate of fitness, health register, report of accident or dangerous occurrence resulting in death or bodily injury, report of dangerous occurrence which does not result in death or bodily injury. Notice of poisoning, then abstract of Factories Act annual return, half yearly return, muster roll, and register of accidents and dangerous occurrences. We come to section 112. This is the general power to make rules. The state government has been provided with the power to make rules for any matter which under any of the provisions of this act is to be or may be prescribed or which may be considered expedient in order to give effects to the purposes of this act. However, under section 113, that is 113, the center has the power to give directions to the state government for carrying out the executions of the provisions of this act. Let us come to the occupational health records that need to be maintained. First is the results of physical examination of all the workers, including the x-rays, lab and other diagnostic study reports which were carried out. Then in case there were any acute emergencies, that is like suppose there was poisoning or there was respiratory distress or there was an accident, then these kinds of acute care entries have to be made and progressive progress notes of the worker have to be recorded. Then immunization records as per job requirement, for example hepatitis B in the case of health workers, tetanus toxoid in the case of people who are handling machinery. Then occupational and medical history recorded for the worker. Another important occupational health record is the hazard exposure record. That is the exposure of the worker to any of the chemicals or body fluids or any other substances. Then health programs participation record of the worker. In case some community health program has been done or a specific health action was done and the workers participated in that, then that record has to be maintained. This includes education and communication also. Very legally important form is the informed consent forms, an authorization for disclosure of information in respect of the worker. This is a very important legal document and must be carefully kept by all the industry. We are maintaining so many records and forms. What is the purpose of occupational health records? This is to centralize the information that helps the assessee and assessors make well-informed decisions when sorting through the inputs for corrective action and improvement action. See, these are not just pieces of paper lying in an almirah. The important thing is that we have to make informed choices and take corrective action and improvement. At any workplace, records, especially the occupational health records, help the healthcare professionals in analyzing the workers' health and treatment options, including the planning for sets of corrective measures by the management. See, although the environmental hazards may also arise of occupational activities, they are not considered as part of the occupational health records. The environmental management system is addressed in a different series, that is the ISO 14000 series, which solely focuses on the environmental domain and not the health domain. The small and medium sized business enterprises require workers' health and safety records and manual, and they are supposed to follow it. The large organizations should have the company's WHS manual, policies and procedures of operation, SOPs, work instructions, safe work method statements, as well as different requisite forms and templates. In the offices, there could be stressors like the work stress, computers, electrical hazards, manual material handling, bullying and harassment. So, all these have to be taken care of. Let us come to the manufacturing sector. Manufacturing sector is exposed to electrical hazards, ergonomic stress, manual material handling, hazardous chemicals, implanting and lifting equipment and heavy weights, then racking and storage, and irregular workplace traffic. Come to an important construction industry, that is the unorganized sector and mostly not looked after, is noise, electrical hazards, manual material handling, confined space, working on heights. It is well known that these poor workers, sometimes they fall off, they even lose their life Recently, my maid's brother, he died in a construction industry in Delhi itself because a stone fell on his head. So construction industry is often neglected, but we need to take care of them. Then while implanting and lifting equipment and heavy weights, racking and storage and workplace traffic, they should be provided with proper gears and taken care of. Unorganized sector workers and non-availability of documentary evidence and records. It is a prime issue in our country. Let us take a case study of a chemical company. So they will have to keep form number 33 pre-employment, form 32 that is periodic medical examination every 6 months, then periodic medical examination every 2 years for a non-hazardous area, then periodic medical examination of drivers with binocular vision report, medical examination of food handlers so that they do not transmit food-borne diseases, factory accident register, illness register, sickness absenteeism and OPD case sheet, fitness register, then the drug stock register, antidote medicine register, especially in the case of factories in which chemicals are used, then the calibration register, first aid box, stock and audit register is important in every workplace, biomedical waste register, spirit license and form number 20. So similar to this case study, depending on the occupation and the factory and the occupier, different forms and different records have to be kept. Now come to the privacy and security of occupational health records. We are maintaining so many records, but does everyone has access to these records? No. Under section 17.1 to 17.3 of ISO 9004 to 1994, they offer guidance in describing the intent behind keeping quality records. They should be retained for a specified manner in such a way that they are readily retrievable. It is no point keeping the records if they are not available when you need them. Okay? Then you have to share them as per compliance with applicable statutory and regulatory requirements. While in storage, they should be protected in suitable facilities from damage, loss and deterioration due to environmental conditions. All occupational health records are to be maintained in their entirety and ensure that no document or entry is deleted from the records or added, except in circumstances where there is a destruction policy or recommendation by law. Handwritten entries are made with permanent ink to ensure the quality of scanning, photocopying and faxing the document. The accessibility becomes important at the occurrence of an emergency, accident, occupational disease or during planning for corrective action and improvement. Now, Haldar iterates that Rule 82R of the Indian Factories Act deals with the accessibility of records to the concerned. The health records as well as records of workers' exposure to the hazardous process should be made accessible under the following conditions. Once every 6 months or immediately after the medical examination, whichever is earlier. Second, when the factory medical officer or the certifying surgeons opines of any manifested signs and symptoms of any notifiable disease for the worker as specified in 3rd schedule of the Acts. C. When the worker leaves the employment. In case of direction from Chief Inspector of Factories, health authorities of the central or state government agencies, Commissioner of Workmen's Compensation, Director ESIC, Medical Benefits or DG. In addition, a copy of the up-to-date health and medical records as well as workers' exposure to hazardous process has to be supplied to the worker on written request. All other medical diagnostic reports of the worker have to be made available for reference to his medical practitioner. Retention time of records is established based on the requirement, liability, legal issues and other relevant contracts. Retention of all records up to a maximum of 5 to 7 years is a general practice. However, in the case of mines, medical records are maintained till the worker is in service and 10 years thereafter because it is a hazardous industry. Disposal of records needs due consideration. Either they can be thrown away or shredded, as well as identification of the person responsible for the control of these actions. Thank you.